if anyone wants to speak, we're going to be here until tomorrow morning. So what I'm going to ask of everyone is to we'll try to keep it to 15 minutes on your side.
I'm sure we can do that.
Welcome, sir.
Thank you, Mr. Chairman. I hope the...
First of all, will you recognize yourself?
Yeah, my name.
And what do you do?
My name is Mark Fitzgibbons, and I'm a resident of Fauquier County. As that paper shows, in my professional career, I write about government abuse at places like the National Law Journal, Chronicle of Philanthropy, Politico, Washington Examiner, and a number of other publications. I am a lawyer. I'm a businessman. Sorry.
Help yourself.
Thank
Here you go, right here. Right here. Right over here, buddy.
And I hope before you consider the substitute, that we can have a chance to discuss the original amendment. And, 1430 does three simple things, and it fixes some problems in the Right to Farm Act. The Right to Farm Act is a paperless tiger. It's meaningless without a number of things, and I think the BONETA bill will fix the Right to Farm Act to make the Right to Farm Act meaningful. First of all, it clarifies that farming includes the traditional and varied forms of commerce. Virginia farmers George Mason, who wrote the Declaration of Rights in Virginia, and George Washington and Thomas Jefferson were farmers. And I think they would mock the notion that special interests such as Farm Bureau could restrict or relegate farming to a specific definition. Farming is as varied as each individual farmer. California artist Catherine Dunn, for example, runs Apifair Farms, where she teaches art class on site and online for children. She sells lavender, hand-stitched milk, cloth bags, dog treats. Like Martha, she has rescued animals. If, under her pursuit of happiness, she lived in Fauquier County, she could be subject to fines and even criminal penalties. She is a farmer, Martha is a farmer. They do farming on agricultural property. Jefferson wrote that the administration of laws is only proper until it ends in the administration of every man's farm by himself. That's all we're trying to do here, is protect the rights of farmers on farm property. We're not trying to change or dictate zoning ordinances. All we're trying to do is protect the rights of farmers. And farming commerce is essential to farming. Right now, the Right to Farm Act protects what the Farm Bureau calls production farming. Without the protections of the commerce of farming, the Right to Farm Act is absolutely meaningless. As to the issue of declaring null and void any county ordinance, Martha's Farm is just a few miles from John Marshall's home. Chief Justice Marshall said that any law repugnant to the Constitution, which is our paramount and supreme law, is null and void. County ordinances do not go through the scrutiny of statutes. They do not go through two legislative chambers. They are not subject to an executive veto. They are more likely to violate constitutional rights than anything this legislature passes. By giving courts the ability to declare county ordinances void for violating constitutional rights, it protects farmers. However, counties meet more frequently and can pass substitute bills that comply with the Constitution if any of their ordinances are declared void. As to the remedies, these are fair, simple, and reasonable. In fact, the Right to Farm Act is a paper tiger without remedies to enforce the Right to Farm Act. The remedies are equal to the fines that counties could impose on farmers plus attorney's fees. If anything, these remedies are not strong enough. Counties have litigation liability insurance, small farmers do not. County officials will not go out of pocket on legal fees when they violate farmers' rights. Small farmers do go out of pocket on legal fees defending against overreaching and unlawful actions by county officials. Frivolous lawsuits against the county will be quickly dismissed. Bureaucratic administrative zoning actions, on the other hand, do not follow the rules of evidence, can violate farmers' rights without due process, and can shut down lawful farm activities. Sovereign immunity is the doctrine that means the king can do no wrong. Ask Martha Boneta whether the county can do no wrong. The doctrine of sovereign immunity is itself limited to good faith violations of law, not intentional acts beyond the duties of government officials, and may be limited by the legislature at any time, as it did not long ago under the Virginia Tort Claims Act. Police departments are subject to lawsuits under 42 U.S.C. 1983 and 1988 for violating constitutional rights under color of state law. Clerks of Virginia County Courts are personally liable for violations of fiduciary duties and wrongful discharge. The remedies in the Boneta Bill may be the most popular of all because they assure the Commonwealth of Virginia that there are consequences when counties violate the rights of citizen farmers. The remedies is merely a prophylactic way to ensure that counties follow the Right to Farm Act. We stand shoulder to shoulder with county officials who are our friends, church members, some of them are our relatives, who respect and follow the law. All we are asking is that county officials do what's expected of everyone in this room, which is respect and follow the law. The bill simply protects farmers' rights. It does not impede on the zoning authority of counties. Now, I understand there's a substitute amendment that would have the Virginia Department of Agriculture and Consumer Services provide a model zoning ordinance. We oppose that. We don't want Richmond telling our county what can be in its zoning law. All we want to do is protect the rights of farmers, protect their constitutional rights, protect their rights to commerce and to farm the way they want to do. What has happened to Martha is unconscionable. She is closed because of uncertain, unlawful, and unscrupulous actions by my county. This bill is simply protecting the rights of farmers all across Virginia. And I ask that you not offer the substitute bill, but that you pass the Boneta bill in its current form, and I'd be happy to answer any questions.
Please, we don't have time.
Yeah.
Thank you, sir. Any questions of committee? Yes, please, John.
You would agree, sir, that when the county passes an ordinance, it's done after a public hearing, at least one, and upon the legal advice of the county attorney as to whether it's legal or not legal under Virginia code?
Yes, they would pass it after a public hearing, but that doesn't mean it wouldn't violate the Constitution of the United States. There are certain laws that are passed periodically that do violate the Constitution, and this gives a court the authority to simply review whether the ordinance is consistent with the Constitution. If it violates the Constitution, it could be declared void, and the county could go back and fix that ordinance rather quickly. Unlike the legislature that meets just once a year, the counties can meet on a moment's notice and pass a substitute ordinance to cure the constitutional violation.